We continue reading the case. An old case against the Bellefield Comprehensive High School, which is now the Bellefield High School. He finally submitted that the presence of the principal at the meeting convened to hear the charges showed a real likelihood of bias. Mr. Robinson, on behalf of the respondent, submitted that the applicant had abandoned her post when she was on leave, and the letters in question did not purport to dismiss her, but only indicated that she should remain away from the school until the board could deal with the matter. He further submitted that the applicant was appointed by the board of the educational institution, and her permanent appointment was approved by the minister on June 16, 1986. She was not a member of the public service, which is governed by the Constitution and the public service regulations. Let me now turn to the first issue. 1. Was the applicant dismissed from her post? The principal is clearly devoid of authority to dismiss an employee of the institution, and has expressly stated in her affidavit that she had not done so. So the affidavit, that's the sworn statement which she signed. The applicant had abandoned her job, having gone on leave without any permission, and in flagrant disregard of the principal's refusal to grant the leave. Okay, so here, the principal of a school is not able to fire an employee, an appointed employee. It is the board that can do so. So here in this case, the principal did not dismiss the employee. The employee actually abandoned her post. Now, besides the fact that a hearing of charges is in the process of being conducted against the applicant, speaks eloquently to the fact that the applicant was not dismissed. In the circumstances, there cannot be any legitimate expectation on the applicant's part to resume her post before an inquiry is considered in the matter. Having left the job without permission from the authorities concerned, it is the unanimous view of the court, in exercise of her judicial discretion, that the applicant should remain off the job until a hearing is heard in the matter. Such hearing should be expeditiously dealt with. We have refrained from dealing more extensively with the facts and circumstances relating to the applicant's absence, since we would like to avoid any prejudice to a fair hearing of the pending charges. Okay. The second issue is whether the proposed hearing under the education regulation is repugnant to the statute of the applicant. Section 91 and 1 education regulation states that the establishment of any public educational institution shall include such categories and numbers of administrative and auxiliary staff as the board of the institution may be authorized to appoint on such terms and conditions as the minister may determine. Section 89.1. The Board of Management is responsible to the minister for the administration of the institution for which it has been appointed, and in disregarding its responsibilities for the board shall be responsible for. There's part A, which is not mentioned as it is not relevant here, but part B says dealing as prescribed in these regulations with the appointment, termination of the appointment, suspension from duty, and other personnel matters in relation to members of staff of the institution. It is clear from the above mentioned regulations, coupled with the letter dated June 16, 1986, directed to the chairman of Bellefield Secondary School, it was Bellefield Secondary School in those days, in respect of the applicant, that she was a permanent employee of the school and governed by the education regulations. Apart from speculation, there is no evidence before us that the applicant was appointed by the Governor General. The submission that the applicant is a member of the public service and governed by the public service regulations is without merit. So the applicant is not regarded as a public servant and governed by public service regulations. Okay. We therefore hold that the applicant's appointment and discipline is governed by the education regulations. So the court states that even though she is not a teacher, she is a secretary, her application, her appointment, is governed by the education regulation. Turning now to the question of whether there was a real likelihood of bias due to the presence of the principal at the meeting, which was convened to hear her charges. There is no evidence to substantiate the allegation that the principal's presence was to influence any deliberation by the board. It must be borne in mind that she was a witness and the actual hearing had not yet commenced. However, when the hearing commenced, her presence at the hearing, except as a witness, should be discouraged. Okay. In all the circumstances, there was no illegality or breach of the rules of natural justice. Further, the applicant, being an employee of the educational institution, is governed by the Education Act and regulation. So you see, as long as someone is an employee, a permanent employee of a school, their employment is governed by the Education Act and the education regulations. Okay? Not the public service regulation, but the education regulation, as long as you're appointed by the Ministry of Education. Now, accordingly, the application for both orders is refused. Our judgment is unanimous. The respondent should pay the costs to be taxed if not agreed. So, here, the respondent should pay the cost to be taxed. Accordingly, the application for both orders is refused. Our judgment is unanimous. The respondent, which would be the school, should pay the costs to be taxed if not agreed. Alright, so that was the case involving the Bellefield Comprehensive High School. And this case dated back to 1994. Now remember to subscribe to this channel and to watch the videos the video that I posted in the description. When you click on more, you will see it.